Hello everyone, welcome back to the channel EduTap. I am Arshdeep Kaur and today we will be dealing with the important questions from the topic of the Specific Relief Act. Today we start with the Specific Relief Act and we will be covering all the important questions and all the important sections of this act, right? So before I start, I would like to tell you that EduTap has come up with test series for both the phases, phase 1 and phase 2 for your SEBI exam. It is going to be very helpful for your revision. It will include chapter-wise tests, sectional tests and full-length tests. We have also come up with a live crash course for both the phases, phase 1 and phase 2. It will include live classes. You will be having more than 60 live classes and you also get the test series I have just mentioned and you also get one-on-one mentor support. So all of you who have not enrolled yet can do so by referring to the link in the description below. We are also running a limited time period offer. Right, so let's begin with our class today. Question number 1. Okay, so before starting the questions, what is Specific Relief Act? Let's talk about it. So Specific Relief Act, it comes into play when your contractual or your civil right is violated. And when such a right is violated and damages or the compensation, it is not an adequate relief, then what happens is specific relief comes into play, right? So when you don't get a sufficient relief under TPA or you don't get it under a contract act or a partnership act or even for the matter of tort. So if a relief is missing from all such acts, then which act comes into play? It is the Specific Relief Act, right? So the word specific in the Specific Relief Act means the very thing that it needs to be fulfilled under an obligation. The very thing that you are demanding, that is why known as the Specific Relief Act, that you want that specific thing, the specific promise that was made to you, that should be fulfilled, right? Specific Relief Act does not give you any rights, right? So what is happening here is that your right is violated under any other law. That law does not provide you with an adequate remedy. Then what happens is you come into SRA and you come into SRA for specific relief or such ever relief that is mentioned in the Specific Relief Act, right? This act, it came into force on 1st March 1964, right? Now let's move on to question number 1. The word and expressions used in the Specific Relief Act 1963 but not defined in the Act have meaning as defined in the Specific Relief Act, Indian Contract Act, Limitation Act, Transfer of Property Act or Civil Procedure Code. It is option B, that is Indian Contract Act, right? So where it is mentioned in section 2E. The Specific Relief Act 1963 provides that all the other words and expressions used herein but not defined and defined in the Indian Contract Act 1872 have the meaning respectively assigned to them in this act. Question number 2. Which new remedy introduced by the Specific Relief Amendment Act 2018? So the answer to this is option B, that is substituted performance, right? In 2018, there has been a major amendment in this act. Okay, so the Specific Relief Amending Act 2018 has eliminated the inadequacy test by substituting the sections 10, section 14 and section 20 entirely. Substituted for performance has been added by this amendment. What is substituted performance? Let's read it. Substituted performance of contract means where a contract is broken, the party who suffers would be entitled to get the contract performed by a third party by his own agency and to recover expenses and costs including compensation from the party who failed to perform his contract. So right, what is substituted performance? Substituted performance basically means that your contract, it was violated by any party, like there was a contract and it was breached by one party, and in that case the party who suffers the loss, he has been given a new remedy. And what is this remedy? This is known as substituted performance. He has been given a right that he can get his contract performed by a third party or through his own agency, right? Let's understand this with an example. For example, there was a contract between the government and between A, right? And the contract was that A has to build a bridge within 4 years and he asked for the consideration of 1 crore rupees, which was approved. Now after 1 year, the government saw that the work of that bridge has not even started yet. So rather than going to the court and asking for the specific performance, the government thought that it would take a lot of time and a lot of time would be wasted, and the public is already getting very disturbed because of this bridge, right? So what the government does is the government employs X, for example, right? So government employs X and X says, okay, I will make this bridge within the given time, but I will be doing that in 1.5 crores. So now the 50 lakhs which are in excess to the previous contract, they are to be paid by who? Are to be paid by A. Who breached the contract, he is going to be liable to pay the expenses and the compensation, right? So this is what substituted performance is. Let's read it again. So substituted performance of a contract means where a contract is broken, the party who suffers would be entitled to get gets the contract performed by the third party. So he has a right that he can get it performed by a third party or by his own agency. What can be his own agency? For example, he is doing it with his own efforts. He is employing his own laborers. So this is what is his own agency. And to recover expenses and cost, including compensation from the party who failed to perform the part of the contract. So now the party who breached the contract, who did not perform the contract, will be liable to pay compensation and the expenses as well. I hope this is clear to you. Moving on, question number 3. As per section dash, specific relief is to be granted only for enforcing individual civil rights and not for enforcing penal rights. So the answer to this question is section 4. Let's read the section. Specific relief can be granted only for the purpose of enforcing individual civil rights. Okay, this I told you. So it is only for the enforcement of the individual civil rights and not for the mere purpose of enforcing penal rights. So a pure question of penal law, it cannot be decided here, but a pure question of civil law can be decided here, and a mixed question of penal law and a mixed question of civil rights can also be dealt with the Specific Relief Act, right? Moving on, question number 4. Which of the following sections of the Specific Relief Act deals with suit by persons dispossessed of immovable property? The answer is option D, that is section 6. Section 6 is very important. You must understand the entire section and we will be reading it now. If any person is dispossessed without his consent of immovable property, otherwise than in due course of law, he or any person through whom he has been in possession or any person claiming through him may by suit recover possession thereof, notwithstanding any other title that may be set up in this suit. So what is happening here is that someone has been dispossessed of a property. We are not talking about the title right now. We are just concerned that someone has been dispossessed of a property and he has been dispossessed of that property without the due course of law, right? He has been evicted from that property forcefully. So this section, it only provides a quick remedy in case you have been dispossessed of your property. So it is only providing a quick remedy and you can only and only recover possession in this section. They are not talking about the title. They are not concerned about that who is the owner of the property. The only concern is the possession. This section is only added so that no person is deprived of his right to shelter, right? So right to shelter, it is included in your right to life. That is why this section comes into play. This is a immediate relief. This is for your immediate relief. This is for your speedy relief, right? So let's understand each word what it is saying, right? So if any person is dispossessed, they are saying any person. They are not saying that it has to be the owner only or it has to be someone who has the rightful possession. So they are saying if any person is dispossessed without his consent. If you have given your consent, right? If you have given your consent and then you are evicting that property, then you do not get relief under this section. For example, there was a landlord and a tenant. The landlord time and again asked the tenant that please leave my premises, please leave my premises, please evict, right? But the tenant was not doing so. Then the landlord asked the tenant that okay, you don't evict it. What you do is you give me that flat for 1 month. I need it for some purpose and I will give it back to you after the completion of this 1 month. Now the tenant agrees, and now after 1 month, if the landlord does not give him the flat, does not give him the possession of that flat, then also he cannot move under this section, right? Because why? Because he evicted the flat, because he came out of the flat, he was dispossessed from the flat with his consent. right? So this is what is saying, if any person is dispossessed without his consent of immovable property, and it must be which property? It must be immovable property. Otherwise than in due course of law. So they have not followed the course of law, otherwise than in course of the law they have dispossessed you. Then he means he is the person who has been dispossessed. He or any person through whom he has been in possession, or any person because of whom you were in possession, he can also file the suit, right? Or any person claiming through him, any person who is claiming through him may by suit recover possession. So the only remedy they are talking about is what? They are only and only talking about recovering the possession thereof, notwithstanding any other title that may be set up in a suit. So they are only talking about what? They are only talking about a suit. So if we read this section, what we get is that even a trespasser, for example, even a trespasser can come to your possession. You are going to dispossess him, and what he can do is he can move to the court under section 6. But this is not the case. In a judgment, the Supreme Court has said that the possession should be settled possession. If you had a settled possession, then only you are liable to file a suit under section 6, right? So if you have settled possession, means what is settled possession? Settled possession means that you had that possession for a long time. It was a settled possession and the owner knew about that possession. The owner had the knowledge that you have that possession, and also the dispossession that has been complete. It is not in the course, but it has been complete. Then only you can come under section 6 and ask for this relief of the recovering of the possession. So this only deals with the possession. It does not bar you from initiating a suit of title in any other time or in the later stage, but in this suit, in this section, you can only and only talk about what? You can only talk about the possession, right? I hope this is clear. Moving on. No suit under this section shall be brought after the expiry of 6 months from the date of the dispossession. So this period is 6 months. You can only bring the suit within 6 months of the date of the dispossession. And why is that? Because it is a quick remedy. It wants to give you a quick remedy. If you do not bring this suit within 6 months, what it implies is that you are not in that state. It is not urgent for you. So that is why this is only and only available to you in urgent matters, right? So this is why it is only 6 months all against the government. You cannot bring a suit under section 6 against the government. No appeal shall lie from any order or decree passed in any suit instituted under this section, nor shall any review of any such order or decree be allowed. So under this section, no appeal and no review lies. Please mark it that no review and no appeal lies under this section. Nothing in this section shall bar any person from suing to establish his title to such property and to recover possession thereof, right? So after this, the rightful owner, he has the right, he can prove his title. This section does not bar you from proving the title, but this section is only meant in cases of emergency, right? When you are evicted forcefully and you do not have shelter, right? So only and only then this section comes into play, but it is not a bar on you. It does not mean that you cannot prove your title in another suit or in later stage, right? I hope this section is clear to you. Moving on, question number 5. What is the period of limitation fixed for filing a suit for agreement of sale of immovable property for specific performance of the contract? The answer is option B, that is 3 years. So let's read it. The Limitation Act provides for a limitation period of a suit of specific performance of agreement of sale of immovable property in Article 54, and the said period of limitation is of 3 years from the purpose of filing the suit of the specific performance. So according to Article 54, it is how many years? It is 3 years, right? Question number 6. How the preventive relief is granted under the Specific Relief Act 1963 by the court? The answer is D, that is both 1 and 2 correct. At the discretion of the court by perpetual injunction, or at the discretion of the court by injunction temporary or perpetual. So if we read section 36, preventive relief is granted in the discretion of the court by injunction. It can be temporary and it can be perpetual. Now what is injunction? Let's let's read the definition first. An injunction is a judicial process whereby a party is ordered to refrain either from doing a particular act or omission, or directed to do a particular act or omission. So basically injunction is of two types, where a court can ask you to or compel you to do a certain thing, or can ask you to refrain from doing a thing, right? So either you have to do a thing, or either you have to refrain from doing a certain thing. This is what this is injunction. And in case it is for not doing a thing, it is, if it is compelling you to not to do a thing, in that case it is known as a restrictive injunction, right? It is termed as what? It is termed as restrictive injunction. And on the other hand, when it is compelling you, to do a certain act, then it is known as mandatory injunction, right? So then it is called what? It is called mandatory injunction. So for example, mandatory injunction can be that the court has asked you to build this wall, this particular wall, you have to build it, and this is a mandatory injunction for you. And for example, that if the court has asked you that you are not allowed to throw your waste in that garden, for example, so this is what the court is refraining you, it is prohibiting you from doing a certain act, it is known as restrictive injunction, right? And restrictive injunction and mandatory injunction, both these injunctions, they can be of two types. One is perpetual and one is temporary. Temporary is given by the court during the course of the case, at any stage of the case, till the court passes another order or till a decree comes up. And the perpetual injunction, it is an injunction by court that the court gives during the decree, at the decree stage, right? So it is given at the decree stage of the case, when the merits of the case, they have been decided. Moving on, question number 7. No substituted performance of the contract shall be undertaken unless the party who suffers such breach has given a notice in writing of not less than dash to the party in breach, calling upon him to perform the contract within such period as specified in the notice, and on his refusal or failure to do so, he may get the same performed by a third party or by his own agency, right? So it is that where we read about the substituted performance, there the party who wants to get it performed by a third party, that party has to first give a notice to the party who breached the contract, and that notice, it has to be of 30 days. Then only the party can move forward and go for the substituted performance, right? So no substituted performance of the contract under subsection 1 shall be undertaken unless the party who suffers such breach has given a notice in writing. That notice, it has to be in writing of not less than 30 days. It has to be of at least 30 days. And what does that notice has to do? It will be to the party in breach, calling upon him to perform the contract, right? So we will be calling the party. We will be calling the party that you come and you perform the contract, or else what will I do? I will get it performed by a third party, right? So to party in breach, calling upon him to perform the contract within such time as specified in the notice, and on his refusal or failure. And in case he refuses or he fails, right? Either he refuses straight away that I am not going to perform this contract, okay, you go ahead, or the time that was mentioned in the notice, within that time he fails to perform that contract, he may get the same performed by a third party or by his own agency. So you can get your contract performed either by third party or by your agency, provided that the party who suffers such breach shall not be entitled to recover the expenses or the cost under subsection 1 unless he has got the contract performed through a third party or by his own agency. So what they are saying is that the party who is making a third party do the contract, he is not liable to get the expenses or get the compensation till the contract has been completely performed by the third party, right? So when the contract is complete by a third party, when it is completed, when the act that was promised in the contract, it is completed by a third party or through his own agency, when that gets completed, then only you can ask for the compensation or the expenses, right? Question number 8. Liquidation of damages not bar to specific performance provided under which section? So the answer to this is section 23. Right? What is liquidation of damages? Liquidation of damages means it was already decided. These damages, in case of a breach, they were already decided between the parties, right? So they are saying liquidation of damages, not a bar to specific performance. In case you have already decided it, then also you can get your contract specifically performed. And when can it happen? Let's read it. A contract otherwise proper to be specifically enforced may be so enforced, though a sum be named in it as the amount to be paid in case of its breach. So what they are saying is, basically there was a contract between two parties, and they already had a clause which said that in case of breach, this much amount is going to be paid by the party who is breaching it. For example, let's say it was 1 lakh rupees that the party who is going to do that breach, who is going to breach the contract, he will be liable to pay 1 lakh rupees. And the party in default is willing to pay the same, and at the same time that party who has done that breach, who has breached the contract, that party is willing to pay, he is ready to pay that 1 lakh rupees. If the court, having regard to the terms of the contract and other attending circumstances, then in that case, what will the court do? The court will read the contract, the entire contract, the terms of the contract, and also see the other circumstances of the case. And if the court is satisfied that the sum was named only for the purpose of securing performance of the contract and not for the purpose of giving the party in default an option of paying money in lieu of the specific performance. So if the court is satisfied that the clause that they have mentioned, it was only meant to increase the seriousness between the parties, right? So that amount, that 1 lakh rupees amount, it was only mentioned in the contract so that it can be a deterrent for both the parties and the breach is not going to happen, right? So it was only for this reason that they added that clause, because they wanted to make both the parties more, because they wanted to make each other more serious about this contract, right? So if this is the case, then in this case, even though that you have mentioned that clause of in case of breach, this will be liable, this much amount will be liable, then also in this case, if this clause was only meant to add seriousness to the contract, then what will happen is, in that case, the court is going to ask the party in breach to perform the contract specifically perform the contract, right? So they are going to grant the relief of specific performance. But on the other hand, for example, after reading the contract and the circumstances, the court came to the conclusion that that amount, that clause was mentioned, it was mentioned in lieu of specific performance. It was mentioned so that they don't have to specifically perform that, right? It was mentioned because they wanted to protect themselves from specific performance, and that is why that amount was mentioned. In that case, the specific performance will not be granted by the court, right? So that is why they are saying an option of paying money in lieu of specific performance. If it was an option of paying money in lieu of the specific performance, so that the specific performance would not be granted, or a party would not go for specific performance, if that was the reason, if that was the case, in that case specific performance is not going to be granted by the court, right? Now let's read the entire section. A contract otherwise proper to be specifically enforced may be so enforced through a sum be named in it as the amount be paid in case of its breach, and the party in default is willing to pay the same. It is willing to pay the same if the court, having regard to the terms of the contract and other attending circumstances, is satisfied that the sum was named only for the purpose of securing the performance of the contract. It was only to secure performance of the contract and not for the purpose of giving the party in default an option of paying money in lieu of specific performance, right? When enforcing specific performance under this section, the court shall not also decree payment of the sum named in the contract. So according to clause 2, if the specific performance has been granted by the court, in that case, the sum that was mentioned, the damages that were mentioned in the contract, they are not going to be paid by the party who breached it, right? The court is only going to grant what? It is only going to grant the specific performance and not ask the party who breached the contract to pay the damages that were mentioned in the clause, right? Let's take an example for this section. For example, suppose there is a person A, he is very rich, he is very famous. He has a son who is 10 years old, and A makes sure that all his wishes, all the son's wishes, they are fulfilled, they are met with, right? So what happens is, one day his son, he sees a dog and he asks his father that I want that dog. That dog belongs to B, for example. A asks B that I want to buy your dog and I will buy it for 10,000 rupees. B is very happy. He says, okay, I am ready to sell my dog to you for 10,000 rupees. They have a contract, they have a written contract, and that contract mentions one thing, that in case that B breaches that contract, what will happen? He will be liable to pay, for example, 1 lakh rupees. This clause, A only adds this clause to add seriousness, so that he can fulfill his son's wish, right? So that is why, only to add seriousness, only to secure performance from B, that is why he adds this clause. Now what happens is, because A is very famous, so what happens is, this news comes in media and everyone is interested in that dog. So everyone wants to know that what is so special about that dog that A is willing to pay 10,000 rupees for it. Now what happens is that B starts getting offers for the dog, and one person, let's say X, he is ready to pay him 2 lakh rupees. So now what B thinks that okay, I will sell my dog for 2 lakh rupees, and what will I do? I will pay A 1 lakh rupees, that is because of my breach, and I will get 1 lakh rupees. So instead of getting 10,000 rupees, I am getting what? I am getting 1 lakh rupees. So in this case, it will do what? Court will go through the terms of the contract and the circumstances, and it will come to the conclusion that B has to sell his dog to A only for 10,000 rupees, because the clause that was mentioned, it was only to secure performance and only to add seriousness to the contract. Right? I hope now this section is clear to you. Moving on, question number 9. The Specific Relief Act 1963 enacted due to the recommendation of the which law commission report? This question is really important for you. So it is the 9th Law Commission. Let's read it. In India, the common law doctrine of equity had traditionally been followed even after it became independent in 1947. However, it was in 1963 that the Specific Relief Act was passed by the Parliament of India following the recommendation of the Law Commission of India in its 9th report on the Act. So it was the 9th Commission. The Specific Relief Act Bill 1962 was introduced in Lok Sabha in June 1962, repealing the earlier Specific Relief Act 1877. So which was it? It was the 9th Law Commission, right? So it was the 9th Law Commission report. Question number 10. Injunction to perform negative agreement provided under which section? It is section 42, right? Let's read this section. Notwithstanding anything contained in clause E of section 41, where a contract comprises an affirmative agreement to do a certain act coupled with a negative agreement, express or implied, not to do certain act, the circumstance that the court is unable to compel specific performance of the affirmative agreement shall not preclude it from granting an injunction to perform the negative agreement. Now what is happening here is that there is a contract which has two obligations, one is positive and one is negative, and now because of say section 14 or section 16 of this act, the court cannot ask the person to specifically perform the positive duty. So according to this section, it does not mean that the court cannot ask the person to do the negative duty as well. The court can ask you, the court can give you instructions that you have to perform that negative duty. So this is what they are saying. So for example, let's say there is a contract between A is a teacher, and there is a school B. So here A is supposed to teach in a school B for 5 years, for example. But but A breaches it and he says that I don't want to perform this contract, right? Now what happens is, because of section 14, the court cannot force A, because it is the personal qualification of that person. So the court cannot force A to teach in that particular school, because the court cannot force you to do a positive thing here, right? But supposingly that contract also had a clause which said that that A cannot teach in X school also, because X school is just adjacent to school A. So in that case, because the court cannot compel you to do the positive thing, but it does not mean that it cannot compel you to do the negative thing also. Here in this case, the court can ask A that if you don't want to teach in B school, then you cannot even teach in X school. So this is what this section is saying. Now let's read it. Now it will be clear to you. Notwithstanding anything contained in clause E of section 41, where a contract comprises an affirmative agreement to do a certain act to teach in school B, coupled with a negative agreement not to teach in school X, express or implied, not to do a certain act, the circumstances that the court is unable to compel specific performance of the affirmative agreement shall not preclude it from granting an injunction to perform the negative agreement. So, court can grant injunction in this case against who? Against that teacher that you will not be teaching in school X also. You are not going to teach in X school as well, provided that the plaintiff has not failed to perform the contract so that as it is binding on him. So, but there is a proviso which says that it should not be because the breach should not be because of the default of the plaintiff. If in this scenario we say that the school was unwilling to pay A, okay? So in that case what will happen is it is not because of A's default, but it is because of B's default. Then the court will not stop A from teaching in X school. But in case that the contract was proper and there was no default of that school, in that case A will be precluded from teaching in X school as well, right? So provided that the plaintiff has not failed to perform the contract so far as it is binding on him. So the plaintiff has performed his side of the obligations. He was ready to do everything and he is ready to do everything, right? So he has not made any default. Then only this section will be applied. Question number 11. Section 31 of the Specific Relief Act 1963 is related to, it is cancellation of instrument, right? So it is cancellation of instrument. Any person against whom a written instrument is void or voidable. In case an instrument is void or voidable and who has a reasonable apprehension that such instrument, if left outstanding, may cause him to serious injury, may also sue to have it adjudged void or voidable, and the court may in its discretion so adjudge it and order it to be delivered up and cancelled. So in a case where an instrument, what is instrument? For example, your will, your sale deed. So for example, an instrument, it has become void or voidable, then you can go to the court and ask the court that please cancel that, okay? Please cancel that instrument so that in future you do not face any problem, right? So this is what they are saying. Any person against whom a written instrument is void or voidable and who has reasonable apprehension, you have that apprehension, such instrument if left outstanding may cause him serious injury, may sue to have adjudged void or voidable, and the court may in its discretion so adjudge it and order it to be delivered up to be cancelled. If the instrument has been registered under the Indian Registration Act, the court shall, so this will be the duty of the court in case it has been cancelled, also send a copy of its decree to the officer in whose office the instrument has been so registered, and such officer shall note the copy of the instrument contained in his books the facts of such cancellation. So the registration, if it is registered, then the court has to send that decree to the registration office as well, so that it can be cancelled there also, so that they can make note that this instrument, this has been what, this has been cancelled. Question number 12. The circumstances under which a perpetual injunction can be granted have been enumerated. It is section 38. Subject to the other provisions contained in or referred to by this chapter, a perpetual injunction may be granted to the plaintiff to prevent the breach of an obligation existing in his favor, whether expressly or by implication. When any such obligation arises from contract, the court shall be guided by the rules and provisions contained under Chapter 2. What is Chapter 2? It is the specific performance. So what does this mean? That in case you cannot get specific performance, you cannot be granted specific performance, then that means that you cannot even be granted an injunction, right? When the defendant invades or threatens to invade the plaintiff's right to or enjoyment of a property, the court may grant perpetual injunction in the following cases. This list of cases, these are not exhaustive. There can be many more examples where perpetual injunction can be granted, but some of the examples that have been mentioned, we can go through them. Where the defendant is trustee of the property for the plaintiff. So in case he is the trustee of the property and he is trying to, for example, sell that property, so in that case a perpetual injunction can be granted against him. So where the defendant is a trustee of the property for the plaintiff, so the plaintiff will be who? The beneficiary. For example, it is the property of the owner. So here the owner is going to sue the trustee in case he is trying to sell the property which he has under such trust, right? where there exists no standard for ascertaining the actual damage caused or likely to be damaged by the invasion. You cannot ascertain what the damages will be, and where the invasion in such the compensation in money would not afford the adequate relief. And in case the money would not be adequate relief because of that invasion, the money would not be adequate relief, then also you can be granted what? You can be granted perpetual injunction. Where the injunction is necessary to prevent a multiplicity of judicial proceedings. So where it is necessary, and if not granted, it will lead to what? It will lead to many litigations. There also you can be granted a perpetual injunction. Now let's just read it. I have explained you what is temporary and perpetual injunction. Let's just go through it. Temporary injunction are such as are to continue until a specific time or until a further order of the court, and they may be granted at any stage of the suit and regulated by the Code of Civil Procedure. So they are granted at any stage of the suit and they continue until either the next order of the court or until a specific time, right? And what is perpetual injunction? A perpetual injunction can only be granted by the decree made at the hearing and upon the merits of the suit. So it can only be given after a decree has been drawn up and after the merits of the case have been decided. So this is perpetual injunction. Question number 13. Possessory title. Possessory title is good against all except the rightful owner. Possession is a good title against all but the true owner, and entitles the possessor to maintain ejectment against any other person than such owner who dispossesses. So a possessory title, it is a good title against all but the owner of the property. Question number 14. The provisions of the Specific Relief Act are founded on public policy. So the provisions of the Specific Relief Act, they are founded on what? They are founded on public policy. Question number 15. In determining the amount of any compensation awarded under Section 21 of the Code shall be guided by the principles specified in, so it is Section 73 of the Indian Contract Act. So in determining the amount of any compensation awarded under this section, the court shall be guided by the principles specified in Section 73 of the Contract Act. In case they have to decide the compensation under Section 21, they will be guided by the section, which section? It will be Section 73 of the Indian Contract Act. Now, question for achievers. The relief by way of mandatory injunction is fundamental right, mandatory, discretionary, obligatory, or none of the above. So you have to comment the right answer below. So that was all for today. I hope it was an helpful session for you. For more such videos, please like, share and subscribe to the channel EduTap. Thank you.